Hello, Stephanie Joy with All Things Social Security. We had a Q&A with a short little clip discussion on a particular topic. So I'm going to attach it for you here. It might be something that you're interested in if you clicked on this header. And following that, we're going to go through it a little bit more. So just wanted to give you the heads up. This is where it started from, and then we'll have the bigger discussion right after. All right, chat with you later. Bye-bye.
There is a term you may hear in the Social Security world called residual functional capacity, and a lot of attorneys call the forms RFC forms. That's technically not accurate because residual functional capacity is a legal conclusion about what your capacity is that is left over, residual, after you factor in all your medical issues. It is a vocational determination that you are limited to sedentary or light work with the following additional limitations. So, what you're trying to prove in a disability case is that vocationally, you would not be reliable or dependable at a job. So the medical issue, you don't, unless you're listing level, the medical is sort of the hinge. I mean, you've got to prove that the medical means something vocational. So if you're medically, you've got a herniated disc and you've got a, knee bone on bone and you've got bad breath, whatever it may be, all those things are great, but if it doesn't limit you vocationally, you're not going to win. So what you really got to focus on is translating the medical into very, very specific vocational limitations. So vocationally, that's what you want to really focus on. And if your doctor will make comments or assessments about the vocational implications of your medical problem, to the extent that they can, that is helpful. So if you're asking, we don't win on a diagnosis A, but if you're asking, the medical issues, are they more important than the vocational? I would say really no, because, the medical diagnosis you don't win or lose. It's the vocational implications of that. And ultimately, a judge has to make a decision. What does it mean? Is it reasonable? Is it logical that this medical problem, the COPD you have, the carpal tunnel you have, the pulmonary issues, the breathing issues you've got, the problems you have, around dust, fumes, and gases, what does that mean in terms of your capacity to do past work or any other work? So maybe that's what you're asking, but I think that's my take, at least, that this is really vocational in nature. What's your thought on that?
Yeah, and when you say vocational, would you be saying the same thing as the functional limitations?
Yeah,
the functional, but when we talk about functional, we're talking about the subset of functioning that would relate to things that are needed for work.
Oh, right, exactly.
Yeah.
Right, you may
Not
have,
like,
right, you could have a functional limitation. This is kind of a silly example, but let's say that you have a really bad burn scar on your hand, okay? But it doesn't affect the use of your hand. Functionally, that might eliminate jobs where you would be a hand model, okay? Or a job where you might have, and it's a silly example, but where your hand, the appearance of your hand might be relevant to something. But functionally, if you can pack and you can lift and carry, that's not a work preclusive limitation. So you really have to think about all these issues in terms of how they're work preclusive. And quite often we see people that have gone to the psychologist or had a CE, consultative evaluation, and they are diagnosed with mild depression or mild anxiety, or they have, mild back pain. Well, mild anything is probably not going to be work preclusive, because most judges will conclude that if you have a mild level of anxiety or depression, maybe that eliminates highly skilled work under a high pressure environment, but 1 or 2 step entry level jobs is probably not going to be limited by a mild depression or mild anxiety. So, you've got to really focus on getting a doctor, if you can, to identify significant, severe work preclusive level type of limitations. And Social Security's got their own little code where, you have things that they talk about, moderate, they have marked limitation is much more significant than a moderate limitation or slight limitation. So you got to get them to define their terms as well. But yes, to answer your question, Steph, I think that vocationally, you really want to focus on how this affects you at a job. And really, most cases turn on simple entry-level jobs, not the complex jobs. With setting aside the grid rules, if you're under 50, you got to prove you can't do anything. And you've been a nurse practitioner, you've been a CPA, but if you can pack ink pens in a box, you're not disabled, right? So it's a heavy burden. Heavy burden.
It is.
All right.
Hey guys, Stephanie Joy here from Joy Disability. Just wanted to touch on the misconception that a medical condition or diagnosis that is a significant one is going to win a case because you have a serious diagnosis. Not true. You need the diagnosis to get to the next step in the sequential evaluation process, but the diagnosis itself isn't going to win the case. With the pseudo exception of compassionate allowances, of which there are not that many relative to the amount of diagnoses out there. And even with a compassionate allowance, you still have to have the current evidence of current treatment and certain criteria met for that to stand. Okay, so what does this mean? Diagnosis isn't going to matter. It matters. It's one of the first steps in the evaluation process that the SSA must go forward with. You have to have valid diagnosis, one or more diagnoses, obviously, might produce more impairments and limitations functionally. And the diagnosis has to be diagnosed in an acceptable manner. And it typically is, so that's not something that I would really worry about. If you were diagnosed with something many years ago before you became disabled, and by the way, that's why diagnoses don't win a case, because most people have diagnoses and they work for years thereafter. It's when the diagnosis of the medically determinable impairment, MDI, once it's determined to be a severe one, which that's not a huge burden either, I might add, that's never our big fight. Once that happens and it starts limiting the person enough that it eliminates their current job is when they tend to either be terminated because they couldn't function well enough to satisfactorily perform the job duties. And by the way, there's a video on getting a statement from your employer about that, which can be really helpful. But also they get out of the first job, then they have to actually, if they have a case, then they have to prove that their impairments prevent all jobs. So that's a whole nother term of art and a whole bunch of legal input, factual and legal input that goes into proving that if it's so. Okay. So the diagnosis itself, again, is not going to be the deciding factor. It's just going to get you across into the next yes in the tree of yes, no's. If yes, you're disabled, or if yes, you're not disabled. It gets you down to where they'll still consider your case versus knocking it out because there's nothing more than a diagnosis. So the diagnosis being currently treated for now, not 2 years ago only, now. I mean, it's nice if it was treated with some duration. For sure. That's more longevity, and durational records are best, but you can't win unless it's now, generally speaking. So you need to be treating for that impairment. And of course, as you'll see in my other videos, treat for every other little one too, not just the one that took you out of your job, because that took you out of one job out of 12,000 that you have to prove you can't do. But those other little impairments that you don't really think about much because you can do workarounds and not have to use that limb or that finger or that this or that. They're the ones that can actually make your case be a winnable one. Because remember, you can't prove, it's not like workers' comp where you prove that you're 70% impaired. It's a totally different definition. And we have to prove that there are zero, for all intents and purposes, zero occupations we can do full time. So even if we could do some activities part-time, that doesn't count against you unilaterally, but that we can't do the job that exists in substantial numbers in the economy full time. So if we can do one job out there that there's only 2 of them in the entire country, that's probably not going to be considered substantial numbers. So it's a whole, more of an official number, a numbering. They have the vocational experts provide the numbers. They use the dictionary of occupational titles and other resources to find out the supposed numbers in the economy. The information is often very outdated. There was a big news article about that finally, what we've been complaining about for a long time. But anyway, so the medical records from your current treatment are not only going to say that there's a diagnosis, but they're also going to, if your doctor is, in my opinion, properly doing his job, or your NP or whoever, describing how they affect you day to day. Because, let's face it, a diagnosis of something that is not terminal and doesn't affect us much, who really cares? I'm diagnosed with a freckle up here, but it doesn't bother me. Is it an impairment of sorts? Sure. But it doesn't bother me. It doesn't limit my work effort. So, I mean, it might if I was going to be like a porcelain model or something, but I'm not. So it doesn't knock out all these substantial jobs. So you have to have current treatment with all of those diagnoses for your strongest case. Any that you forego and decide is too inconvenient to treat for, just know that you are diminishing the strength of your case. Doesn't mean you might not still win by any means, but you have diminished the strength of it. by and large. So diagnosis won't get you there. It's how the functional limitations are caused, to what extent, how severely, and is it enough to prevent all occupations? Simple, sedentary, 5th grade skills, unstressful, supposedly. I think all jobs are stressful, but anyway, that's not how they look at it. Routine, 1-step, 2-step, for those that can't remember very well. We've got to eliminate all those jobs one way or another. Diagnosis, treatment, 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 diagnostic test, treatment, treatment. Can I emphasize it anymore? Anyway, diagnosis isn't going to win it. You have to treat, and you have to treat with certain providers, not certain providers, certain professionals for a stronger case. Some professionals are acceptable medical evidence, some are not. So you need to know the difference. So do your homework or find someone who can do it for you. Okay. All righty. Hope that helps. Bye.